You did the responsible thing. You made a will, maybe you even made a trust. You told your lawyer who should get what. But years ago, you filled out a beneficiary form for your IRA or IRA. Maybe it was when you opened the account, maybe it was before a marriage, a divorce, a death in the family, or the birth of grandchildren. And that old form may still control who gets the money. Not your will, not your trust, that form. I'm David Shulman, and I'm here with my partner, Jill Ginsberg. Today, we're talking about one of the simplest estate planning mistakes and one of the most expensive, old beneficiary forms. These are forms you fill out for retirement accounts, life insurance, annuities, and sometimes bank or investment accounts. They say who gets the money when you die. And for many people, those forms matter more than the will.
That surprises people. They think, I just did my estate plan. I signed everything. My lawyer knows what I want. But if the beneficiary form still names the wrong person, the account may go to the wrong person.
Exactly. Think of it this way. Your will does not necessarily control everything you own. If your IRA says your brother is the beneficiary, then your IRA may go to your brother, even if your will says everything goes to your children. If your life insurance names someone who is no longer in your life, that can create a serious problem. If your 401k form is blank, the company may have its own default rules about who gets the money. The form on file is what the company is going to follow.
Families often find this out after it's too late. A parent dies, the children think everything's supposed to be divided one way. They call the IRA company or the insurance company and find out that the account is going somewhere else. And at that point, the company is usually just following the paperwork that it has.
Right. So, Jill, let's talk about the most common mistakes.
Well, first, the form is old.
Well, that's a big one. Someone filled it out 20 years ago and never looked at it again. Since then, there may have been a marriage, a divorce, a death, new children, new grandchildren, or falling out in the family, but the form never changed. And when that person dies, the account generally goes to where the old form says it does.
People update their phones more often than they update the paperwork that controls hundreds of thousands or even millions of dollars.
That is exactly right.
Second, the form is blank, incomplete, or missing.
People assume that if there's no beneficiary listed, the will takes over. That may sometimes be true, but it often creates delays, extra costs, accelerated taxes, or a result nobody expected. Also, the accountant company may have their own default rules. The money may have to go through probate, and the family may be stuck sorting it out during an already painful time.
So the I never filled it out is a problem.
Correct. Having an incomplete form itself is a decision, just not the one you wanted.
Third problem, naming minor children directly.
This comes up a lot with grandchildren. A grandparent wants to leave money to the grandkids, so they list the grandchildren by name as the beneficiary. But if a child is under 18, the company will not just hand the money over. Now, the family may need to go to court and establish a guardianship. There may be legal fees, reports, and restrictions. And then when the child reaches the age of 18, the money may go to her outright.
Which means an 18-year-old can suddenly receive a large amount of money with no guardrails.
Exactly. If you want to leave money for minor children or grandchildren, there are better ways to do it, such as naming a properly drafted trust as the beneficiary of your IRA.
Fourth, naming a person with a disability directly.
That's another painful one. A parent wants to provide a child who receives government benefits because they have special needs, so the parent names the child directly on the IRA or life insurance policy as the beneficiary. The parent dies, the child receives the money, and now the inheritance that they receive may put the child's benefits at risk.
And the tragedy is that the parents have already created a special needs trust for that child. They did the planning, they cared deeply, but if the beneficiary form sends the money directly to the child instead of to the trust, that plan may not work.
Exactly. For a beneficiary who receives needs-based benefits, the wording matters. The accounts will usually be directed to the right kind of trust, special needs trust, and not directly to the person.
Here is your homework. Pull your beneficiary forms, not just one of them, all of them. Look at your IRA, your 401k, your 403b, your life insurance, annuities, and any accounts that have pay on death or transfer on death beneficiaries. Check who's listed first. Check who's listed as a backup. Make sure all the percentages add up. Make sure the people are still the right people. Ask yourself, if I died tomorrow, would this form send the money to where I actually want it to go?